morning, everyone, or afternoon, as the time may be where you are. I hope you are all doing well today. Thank you all for coming. I can see the room is filling up quite quickly, so that's good to see. All right, as usual, I know you're not here to see me, you're here to see our presenter, Cagdas, so I will very quickly go through my introduction of the ICCP for anyone in attendance who is joining us for the first time. Who are we? Who is the ICCP? We are a professional members organization that recognizes those with skills, qualifications, and expertise in the professional management of construction claims. And we have three objectives: to establish international professional standards, to give recognition to those who have gained the appropriate knowledge and skills, and to help and educate those who wish to gain that experience in the management of claims. And why is there a need for the ICCP with so many professional organizations in the construction industry? Quite simply, until the ICCP was established, there was no institute that specifically recognized those who have the specialist knowledge, experience, and skills to be able to manage, prepare, and respond to claims to the highest levels of professionalism. Okay, I'll quickly introduce the steering committee. Our executive officer, Andy Hewitt, our president, Paul Gibbons, and we have three elected fellows. I am currently providing maternity cover for the general manager, Nina Hewitt Tyrell. Okay, and in terms of membership, we have 3 levels of individual membership, and we are about to announce 2 new levels of membership, which will be student membership and graduate membership. So that announcement should be going out in the next week or so. So we will then have 5 levels of individual membership. And we also have a corporate membership for either claims consultancies or companies that have departments specializing in claims. Okay, and so what is in it for the members? Why should someone join the ICCP? Well, we have a private members area, which has a library of articles, white papers, case studies, etc., information about further education and training opportunities. We have a bookshop, doesn't actually sell books. We have information about the latest releases related to contracts and claims. We have a growing library of templates to help our members save time and ensure that their claims are to the highest standard possible. We also have regular CPD webinars such as this one. So members will get a CPD certificate for today's event, those of you who attended. And we have the ICCP Academy, which are technical training for members to elevate their claims management skills. We have discounts on books from Wiley Blackwell and Rutledge, and we also have a 10% savings on training from our training partner Claims Class. We have a monthly newsletter to keep members up to date with what's going on, and we offer industry exposure by having all members listed on our website. Members also receive a certificate of membership and a logo which shows their designation. We have a private LinkedIn group for members to confidentially discuss their contracts and claims questions. And we have the optional benefit of the Register of Claims Practitioners for those members who would like to increase their online profile, generally speaking, consultants. Okay, so I know that was very quick. If you would like more information, if you requested more information when you signed up for today's session, I will be emailing you in the next day or two with more information. Otherwise, you can visit our website, instituteccp.com, or email me, jennifer.smith@instituteccp.com. And with that whirlwind tour, I will go ahead and turn the session over to Cagdas.
Thanks, Jen. Okay, guys, thank you all for joining again. My name is Cagdas Evren Bayrak. I'm a civil engineer by profession. I have 2 degrees in construction law. I'm a fellow member of the Institute of Construction Claims Practitioners, of course, a fellow member of the Chartered Institute of Arbitrators, and I'm a member of some other organizations as well. Today we will be talking about time bars and how to overcome them. So a quick introduction as to what are time bars. You guys are of course familiar with this. In the context of a construction contract, is that a time bar provision is one requires a certain action, usually from the contractor, within a specific timeline for entitlement to relief, cost, or extension of time. It's usually almost always a condition precedent to entitlement. So if the contractor of whatever party, depending on nature of the contract, failed to provide a notice to make a claim within the time limit, that he's not entitled to relief, and he loses pretty much all his rights. Now, the pros of time bars, actually, and this is my opinion as well, I think time bars are a useful mechanism which allows the problems not to fester until the end of the project, and so that the parties can be more proactive and can address the issues as they arise. And important here, a time bar provision allows the employer to take necessary actions. I mean, to find additional funds, to find more money, or to terminate the contract or whatever. So therefore, it's pretty useful for the employer as well. Of course, there are cons. Sorry. It promotes, and this is a fact actually, it promotes a claims culture that may hinder the productivity, or managerial resources of the contractor, engineer, the employer. And it usually, strict time bar provisions result in appearance of claim managers at the early stage of projects. This may be a good thing for us claims practitioners, by the way. And according to some, writers or critics, found draconian, doubtful feature, most blatant as regards to unequal treatment between the employer and the contractor. So there are other people who criticize the time bars as well. Well, I'm somewhere in between. I think we definitely need time bars, but as long as they're properly and fairly managed. And time bar clause in standard form construction contracts. Long story short, before FIDIC 99 suite, there were no time bars per se. They were very rare, and they were requested on specific things rather than like a general requirement in the contract. So it all started, we can say it all started with the FIDIC 99 suite. The position in UK is that the standard form construction contracts, they didn't have such provisions at all. And NEC 3, clause 61.3, which also is a time bar provision, it was introduced 6 years after FIDIC 99. So it all started with FIDIC 99. You are all aware of, I think, this clause, the famous 20.1 in FIDIC 99 Red Book. I'm not going to read it for you, but it practically says, if the contractor fails to give notice of claim within such period of 28 days, the time for completion shall not be extended, the contractor shall not be entitled to additional payment, and the player shall be discharged, this is important, shall be discharged from all liability in connection with the claim. And there's a similar provision in NEC 3. If the contractor notifies the project manager of an event which has happened or which he expects to happen as a compensation event, if the contractor believes that the event is a compensation event, and the project manager has not notified the event to the contractor, and if the contractor does not notify compensation event within 8 weeks, as you can see, it's a larger window there, or becoming aware of the event, and it doesn't say, by the way, should have become aware, contrary to FIDIC, he's not entitled to change in the prices, completion date, yada yada. He's not entitled to anything. I will touch base on that later, but JCT is much more flexible compared to NEC and FIDIC. So, but I think we'll be talking about it. So now, how to get around time bars? I think this is the part where you guys are interested. Well, the strongest course of action you guys can take with regard to getting around time bars would be the law card. What does it mean? You have to refer to the applicable law of the country. And now it makes a big difference if the country is a common law country or a civil law country. Again, long story short, in common law countries, it's very difficult to overcome time bars as you know them. But in civil law jurisdictions, you have relatively a better chance to get around the time bars. Now, first, common law jurisdictions, as I said, it's difficult. So I'm gonna go a little bit quickly on that one. And the most significant ways in order for usually contractors to get around the time bar provision is prevention by the employer, unfair contract terms act, waiver and estoppel, and good faith. But as I said, you don't have you have to bear in mind that you don't have big chances to be successful in relation to time bar provisions in a common law jurisdiction. So what's the prevention principle? Again, I think most of you guys are familiar with this. It basically is a party shall not breach from its own shall not benefit from its own breach of contract. In Peake and McKinley, Judge Alderson's Laysborough part. Okay, this case is significant because it basically says that if there is an extension of time mechanism in the contract, and if the contractor did not follow this mechanism properly, then we cannot talk about the prevention principle. So that's kind of important, and pretty much all standard from construction contracts now have ample provisions in relation to extension of time. There are many grounds and so on and so forth. So if the contractor does not properly follow the mechanism say in the contract, then we cannot talk about prevention principle in general. So let's say further on the prevention principle. I mean, it has to be, in order for an argument in relation to prevention principle to be successful in a common law jurisdiction country, is that it really has to be like a willful misconduct of the employer. I mean, there has to be an intent of acting in bad faith, and I will touch base on bad faith as well. But it's difficult, and it has to be on specific circumstances. It doesn't apply usually, So, but it's not impossible. Of course, there are a few examples in this regard which were successful. Unfair contract terms. Again, this is another difficult one to apply. There's a section within the act called the test of reasonableness. And in commercial management investments and Mitchell design, this reasonableness test was applied on FIDIC contracts, and the FIDIC time bar provision is passed. So it was found by the court that the FIDIC provision in relation to time bars is reasonable. And more importantly, construction contracts are usually between two well-informed and experienced parties, an experienced contractor and usually an experienced developer. So it's unlikely, it's difficult for the unfair contract terms to apply. However, if these terms of some firm contracts are amended amateurishly, I mean, if particular conditions were drafted by some amateurs, or if you're talking about the bespoke contract, then yes, then we can talk about perhaps application of the Unfair Contract Terms Act, but it's a long shot, to be honest. Waiver and estoppel may apply in some circumstances, some limited circumstances as well. It basically is the loss of right or cassation of entitlement to the performance of the contractual obligation, either temporarily or permanently, through an act which shows that the contracting party in question is intentionally not intending to enforce the contractual right or to require the performance of the contractual obligation. This may be applicable, for example, on a partnership-based contract that includes a requirement for the parties to act in a spirit of mutual trust and cooperation. What does it mean? The parties, I mean, the employer has sort of promised to act in a spirit of mutual trust and cooperation. So it may be unreasonable for the employer to insist on strict compliance with the contractual time bar, especially when the contractor can claim that the notice was not served in time limit in the spirit of mutual trust and cooperation. I think there's an actual case in this regard. I don't remember which one, but again, it's, to be honest, it's a long shot. And what does estoppel mean in this regard? And we will look at this in detail later in the civil law jurisdictions. It means, for example, the employer is not strictly applying the time bars from the outset of the project for 2 years, and all of a sudden they decided to strictly apply the time bars. So that may on some circumstances may constitute estoppel. Good faith, again, good faith is substantially different from what it means in civil law jurisdictions and in common law jurisdictions. I remember, I think, a judge in Singapore a couple of months ago basically making fun of the term good faith, you know. So there is no general definition of good faith in common law countries, and some judges think it doesn't apply at all. But however, of course, it's not completely, you know, it's not completely omitted. You can see, you know, at least associated requirements associated with good faith principle in common law countries as well. However, again, in summary, freedom to contract is paramount in common law. So good faith is not an overriding obligation as opposed to civil law jurisdictions. I will explain further on that. And so getting around time bars based on, you know, the good faith is again difficult, but not impossible in common law jurisdictions. However, in civil law jurisdictions, you guys have better chances to be successful in relation to challenging the time bar provision of a contract. This time, the principle of good faith can be a very useful tool. Limitation prescription periods. This is kind of a borderline academic subject, but I will touch base on that as well. Prevention and unjust enrichment, and waiver and estoppel. So pretty much all civil codes, and the thing about civil codes is like in the Gulf region, for example, pretty much all civil codes are I mean, the origin of all civil codes is Egyptian civil code, and Egyptian civil code is basically copy paste of French civil code. So you can see a clear connection between the civil codes of these countries, these civil law countries, especially in connection with the principle of good faith. This good faith principle usually extends to that the performance should be in accordance with custom and nature of transaction as well. So you should act in good faith, you should perform in good faith in accordance with custom and the nature of transaction. And the important difference here, as I said before, is that good faith obligation in these countries is usually an overriding obligation, which means the courts have the right to set aside certain terms and conditions of the contract, sometimes including time bar provisions, and make a decision. There are some specific examples in this regard, and I personally was involved in some of these examples in Qatar, so I know for myself that the contractors were successful by going to court and getting an injunction in relation to temporary suspension of all the time, not only claim related, but all time bars under this contract. For example, let me explain. Think about a situation where the employer had full knowledge of an event of a circumstance, and especially, and this is important, especially pre-contract. So before entering into the contract, they knew the certainty of or something being very likely to happen after the contract was signed, and that would make the contractor entitled to extension of time or money or both. Okay. And when the confirmation post-contract, if these, these discussions were made and recorded in site meetings, progress reports, monthly reports, correspondence, wherever, and if the contractor makes a claim, say after 6 months, and if the employee rejects this claim only based on the time bar provision, then it's very likely that if it's escalated to court or arbitration, then it's very likely that the tribunal or the judge will decide in favor of the contractor in relation to whether the time bar provision was fulfilled or not. Okay, because this demonstrates not good faith on the account of the employer. The employer knew all along. The employer, especially before contract, and that's important. Before contract, they knew, they were well aware of this event or circumstance. And I'm not talking about underground conditions or something. I'm talking, for example, and as I said, this was an actual case. Another state authority tends to start a project which would significantly affect our project, and the employer had this information before making the contract. They did not share this information to a full extent, to a satisfactory extent with the contractor. And after award, this issue was discussed on many meetings, it was recorded in correspondence and monthly reports and so on and so forth. But after some time, the contractor raised the claim when it became apparent that this will be an issue for them. The employer rejected it only based on the time bar. They said you're too late to yada yada, and the contractor went to court and they got an interim injunction in 20 minutes. Okay, so yeah, so this is an actual case. It can also be reduced that the duty of good faith imposes on the employer an obligation to cooperate with the contractor and inform him of any potential event that may cause the contractor substantial financial losses notwithstanding contract's obligation to present formal notification to the employer within 28 days. Yes. So this good faith principle in civil law jurisdictions extends that the contractor, the employer also needs to cooperate with the contractor so that they don't lose money. So that's significant in comparison with the common law countries. This also relates to the direct purpose of the contract. I will go quickly on this one because the nature of commercial contracts and construction contracts are slightly different in the context of application of good faith, which means the direct purpose of a seller would be collect the price of the item being sold, and whereas the direct purpose of the buyer will be to purchase the item being sold on a sales contract. So in such cases, even in civil law jurisdictions, it's likely that common law principles, similar common law principles will apply. Now this is a very long subject, and I will go quickly on this one. Because there was a lot of discussion in the construction law community as to whether the time bars are applicable at all in the Middle East and North Africa region or in the Gulf region general. And the discussions, took place in Egypt, in UAE, in many countries. And the reason of these discussions there were two main reasons. Civil codes, they have strict provisions in relation to time bars. The limitation period or the statute of limitations is considered a public policy, and therefore this is not something which the contracting parties could amend. The contracting parties could not impose a shorter period in relation to statute of limitations. This is a specific requirement, for example, in the Egyptian civil code and other civil codes. Therefore, this was considered, the FIDIC time bars or the NEC time bars were considered as a change in relation to this mandatory civil code provision. So there were long debates as to the applicability of time bars. And another important one is, especially in the Gulf region, because as you may know, Gulf countries are a mixture of civil law and Sharia law. And there's another fundamental principle in Sharia law which can be summarized as a just claim never dies. So based on these two main reasons, there were years and years of discussions, and right now I can say, presiding with you, is that time bars in standard form construction contract especially are pre-collision periods rather than prescription limitation periods. Don't ask me the difference. And the parties' rights to freedom of contract is favored by the courts. So the freedom of contract, especially in relation to the parties' right to decide on a shorter limitation period, is usually accepted by the courts. But again, I was personally involved in a court case here in Qatar that the contractor, they challenged the time bar provisions based on this. They said just claim never dies, and they were successful, at least in the court of first instance. Their claim was successful, their argument was successful in the court of first instance, but I don't know what happened in the court of appeal. So there's prevention and unjust enrichment. These two go hand to hand with the good faith principle. Because they all relate to, after all, the concept of equity and fair dealing. This is similar to the example I have just given you guys. if the time bar is a sole ground, and this is important, if a claim is rejected only because of a time bar provision, then if this claim especially is very substantial, it may jeopardize the whole business of the contractor. And if the employer is not playing ball on this, or if it is relation to especially an employer breach or a variation, for example, then it's very likely that the time bar provisions may not be applicable. And again, I'm right now I'm dealing with a case here in Qatar. The contract is challenging some substantial clause in the contract based on the argument that the variations which were raised by the employer actually invoke Article 63 of the Qatar Civil Code, which is like the exact wording in Article 183 of the Egyptian Civil Code, that render the parties exercise, I mean, the employee's right to exercise his rights under the contract. So they are saying the employer did something, and although they have the right to exercise their rights under the contract, because of what they did, and due to, in accordance with Article 63 or Article 183 or whatever, they are not entitled to exercising their rights under the contract. So this is like a clear mechanism to set aside the employer's rights, not only in relation to time bars, but in relation to other things under the contract. But to be honest, this is difficult to prove for the contractor. This is difficult to prove, and it's a very strong argument. But if it holds, then the whole game may change. And as I said, the judges in civil law countries, they have the right to reduce or completely set aside the damages claimed by the employer under the contract. And these damages can be in the form of liquidated and ascertained damages. For example, if the employer by his own fault has contributed to the cause of or increased the loss, or he has not suffered any loss. This is, for example, this is a clear requirement in Qatar Civil Code, that if the contractor can prove that the employer has not suffered any loss, then the judge has the right to set aside the complete liquidated damages clause of the contract, or the LDs, the liquidated damages, were grossly exaggerated. Again, in that case, the judge has the right to reduce them. There's a question from Ammar. What are the changes in 2017 edition of FIDIC brought related to time? Well, that's a very long subject, Ammar. It's a very long subject. Let me see what I can do. What I can do on this. But in brief, I can tell you that I personally find the 2017 edition much improved in relation to administration of claims in general. So to be honest, I find it very improved. Let's see. Waiver and estoppel, similar to the concept itself is similar to the common law, but the applicability is slightly different. As I said, if the employer just does not apply the time bar provisions for 2 years, and after 2 years they immediately decide to strictly apply time bars, then this may constitute estoppel. Because the recurrence of such incidents can lead to the understanding that the strict requirement of the notice within a specified period has been waived or voluntarily released by the employer. So this may be a very strong argument for the contract, So the chances of challenging time bar provisions in relation to waiver and estoppel would be a stronger argument in civil law countries. So now This is the low angle, and you guys need to bear in mind that for most of the cases when dealing with law, you may need a court order or you may need a tribunal decision, because the engineer or the employer most likely will be reluctant to fully apply a requirement under the law unless they have a specific court order which applies to the facts of the project, and they would be right to some extent. However, in some circumstances, they may be more reasonable, and you can give some examples. You can show some other precedent cases, and maybe they will accept. But most likely, I can say 80–90% of all the cases, they may require a court order in this regard. We have another question. Okay. So now we will talk about the practical ways to get around the time bar. So what we can do without going to lawyer or without going to court. There are some tactics. Yes, there are indeed some tactics which you guys can consider to get around time bars. And I will give specific examples from FIDIC 99 and 2017 suites. I have some. I think I have some other examples from the NEC, but I personally favor to give you guys examples from the FIDIC suite, which I was personally involved. I mean, these are personally tested, so they may work. They usually work, actually. So the first one, design deficiencies in employer design contracts, in the red book contract. This doesn't apply much in the yellow book or the silver book, but if there's an employer design contract, you may need to think about design deficiencies. I will explain further now. There are some notices which should be given promptly, and promptly is not a defined term. So it's not within 28 days, not within 40 days, but it should be given promptly. And this is something which you can use for benefit as well. And the intention to claim and the advance early warnings can also be very useful. I will explain further on that. And lastly, you need to consider choosing the best standard form of contract for your project if you have the chance to do this. So design deficiencies. In the Gulf region, I think I don't remember coming across a project where the design was not even significantly flawed in many aspects. I mean, because pretty much all projects are fast track and there are limited resources available for the designers, for the employer, for those who are supposed to make the design, review the design. So there are always flaws in the design. And in the red book, in subcode 99 red book in 1.8, it says if a party becomes aware of an error or defect of a technical nature. Now in the 2017 suite, they amended this, and it says now whether of a technical nature or otherwise, in a document, it doesn't necessarily need to be designed, maybe specification, maybe anything, which is prepared for use and executing the works. The party, maybe the contractor or employer, shall promptly give notice to the other party of such error or defect. So you need to give a prompt notice. However, for example, in the yellow book, there's a specific clause in relation to the review of the employer's requirements, and you have to conduct a very thorough review within, if I'm not mistaken, within 42 days, and you have to come up with everything, every defect, every potential discrepancy, every potential issue, and you need to notify the client accordingly. Otherwise, you may lose your rights. Whereas in the red book, this is not that straightforward. So if the crux of the claim, or I mean the contractor's claim, is somehow relates to a design flaw, then you have the right to argue that it has only now, or it has only recently became apparent to us, and we gave you a prompt notice. Now, as I said, this prompt is not a defined term. So for you, it may be 2 months. You know, there is room for you to exploit this. If it relates to a design flow, there's more flexibility in this regard. So this is something you need to bear in mind. And I'm using this tactic, you know, a lot in employee design contracts. And yeah, because such defects in design may be apparent after years, after 2 years from commencement date, and nobody can cross question you on that one, because yes, you have the obligation, the contract has the obligation to review design and should be experienced contract and yada yada, but there are many things which can only be apparent, which can only be seen by an experienced contractor or whomever when the works progress to a certain stage. So this may be a very strong argument, as I said, for a claim. So what happens? First, you raise a notice under this clause, under 1.8, and then depending on the employer's response, it may be a variation. If they challenge you, then you can claim and yada yada, which will be to your advantage, in relation to time bars. As I said, this is not a useful tactic at all in contract or design contracts. So because there's a time bar, you have to review the employer's requirements and give notice to the engineer or employer accordingly. Prompt notices. This is I separated design issues from other prompt notices, but this is also a similar tactic. In many clauses in the 99 or 2017 Red Book, the contractor shall give a prompt notice. It doesn't give a specific time period for the notice of claim. It says should be promptly made. For example, in 4.20, it says the contractor shall then or let me start from the beginning. The employer shall supply free of charge, free issued materials if any, in accordance with the details stated in the specification. The employer shall, at his risk and cost, provide these materials at the time and place specified in the contract. The contractor shall then visually inspect them and shall promptly give notice to the engineer of any shortage, yada yada yada. Shall promptly. 4.21 forces, and this was an actual case. I was personally involved in Istanbul, Turkey. We came across an ancient port, and I'm not exaggerating, we changed the course of history. And it only became apparent after the discovery of this thing. I mean, after the discovery of certain findings, only I think after 4 months or 5 months, it rendered certain that these findings constitute fossils for the purposes of subclause 4.24, and then we issued the notice of claim. It was successful. They could not challenge us, as to why you didn't raise the notice when you see something immediately when you dig the claim, because you don't know. You don't know. We gave the notice as soon as we gave a prompt notice as soon as we understood that that issue was significant. And this is a good one for you guys. I mean, especially in the COVID situation. again, in 17.4, it says, if and to the extent any of this stated in clause 17.3, which is employer's risks here, the contractor shall promptly give notice to the engineer and shall rectify this loss of damage to the extent required by the engineer. So the employer risk events are here. And clause H is important here. Any operation of the forces of nature which is unforeseeable, against which an experienced contractor could not reasonably have been expected to have taken adequate preventive precautions. So if something in something listed in 17.3 happens, you're supposed to give prompt notice. There's no time bar, prompt notice, and prompt is somewhat subjective. Advance or early warnings and intentions claim. The thing is, my observation is that one of the main reasons. Okay, we received more questions. Just a second. Okay. One of the main reasons why the contractors hesitate to issue notice of claim is not to irritate the employer. They don't want to make the employer angry. And my observation is that this is one of the main reasons why contractors, do not choose to issue straightforward notices to claim. They usually say, for example, we reserve our right to claim, and such things, but they refrain from, they hesitate to issue straightforward notices to claim. And for this very reason, in FIDIC 2017 suite, now there is a new clause called advance warning. And there are similar provisions in other standard from contracts as well. My recommendation is use advance warning as much as you can. Okay. It says each party shall advise, and it says each party, maybe either party, shall advise the other and the engineer shall advise the parties in advance of any known or probable future events or circumstances which may adversely affect the work, yada, yada, yada. And the engineer may request the contractor to submit a proposal to minimize the impact. This advance warning actually is an outcome of FIDIC's recent strategy to encourage collaboration in contracts, and now they're working on a collaborative conditional contract altogether, which will take some time, I think, but they're working on it. So this basically allows you to win time. You're not making a claim, yet you're not being completely unresponsive. You're not hesitating, or you're not, just doing nothing. You're raising an advance warning. In my opinion, if this is applicable in your contract, use it. In FIDIC 99, the similar provision was there, but it wasn't a separate clause. It was a paragraph under 3.8, which pretty much says the same thing. The contractor shall, but this time it's only the contractor, shall promptly give notice to the engineer of specific probable future events or circumstances which may adversely affect the work, increase the contract price, or delay the execution of the works. The engineer may require the contractor to submit an estimate of the anticipated effect of the future event circumstances under the proposal under 13.3. So this is not a notice of claim, but it's a very useful tool for you to raise your voice and not irritate the employer at the same time. So my recommendation is use the advance warning clauses, you guys. In NEC, there's a similar clause, clause 16, which makes clear that circumstances in which either party should be expected to issue an early warning notice. The nomenclature there is, I think, is early warning notice, and an early warning notice must be issued as soon as the party becomes aware of any matter which could affect the total of the prices, could delay completion of a key date, or may impair the performance of the works. There's a key case in this regard, and I think I will mention this in one of the questions as well. And this relates to not early warnings per se, but let's say the crystallization of the intention to claim. If you have time, just Google this case and you will see for yourself. I don't have the time to go deep on this one. And the judge found in favor of the employer, but his remarks were important because he basically said that especially if the delay or cost effect is not felt until some time, then the time bar starts only after this is felt. So he did not strictly apply, and this was a FIDIC contract, by the way, this OHL and Attorney General. It was a FIDIC contract, and therefore he did not strictly apply the time bar provision there. He said, for this particular case, he said the claim, the notice of claim could only be raised when it was evident, when it was seen, when it was felt that this issue would be a problem for the contract. So this is a very significant case in this regard. And finally, you may need to think about other conditions of contract, or find the most flexible conditions of contract for your project. Of course, if you have the time, if you have the chance to do anything in this regard. For example, and this is literally fresh out of the oven, 2021 Green Book. I had a chance to quickly go through, and there's a significant improvement in this regard in relation to time bars. And Green Book now is not like the previous Green Book. I personally find the previous Green Book pretty much useless, but this one is pretty good. This one's pretty good, and for not capital or not major projects, this may be a very good alternative, I think. And this relates to one of the question of Amar regarding changes in 2017 edition of FIDIC. So this is a very good example. In 2017 suite, the engineer now has the explicit right to remove certain time bars. This is completely new. The new subclause 20.2.5 provides the engineer with the power to waive a failure to follow a time bar requirement. The engineer needs to take into account whether the other party would be prejudiced by acceptance of the late submission, and whether the other party had prior knowledge of the event in question or basis of claim. And this, if you remember, this relates to the prevention principle, which I was talking about. Now, there is more flexibility in 2017 suite, and the engineer has now the authority to remove certain time bars under certain circumstances. JCT suite of contracts, compared to FIDIC and NEC, is the most flexible one. I mean, there are no strict time bars, and the contractor must raise a notice as soon as he becomes aware within reasonable period. So you may consider using the JCT suite if you're allergic to time bars. Okay. And finally, guys, okay, there are ways to get around time bars, but of course we need to do our job properly. I mean, we need to issue the notices timely. We need to follow all the, not only time bars, but all the procedural requirements of the contract strictly. And we shouldn't be relying on any workarounds. And one trick for you guys here is that make sure that you're following, I don't know, LinkedIn accounts of lawyers or following some magazines, I don't know, but in your jurisdiction, make sure that you are timely aware of any changes in the laws and legislation of the country. Because any changes in the law and legislation of the country usually is a very strong ground for the contract to claim. However, there's something you need to bear in mind that for example, in FIDIC contracts 13.7, it says an adjustment to the contract price. So it doesn't necessarily should be an increase, maybe a decrease as well. However, as I said, my recommendation is that you follow closely any changes in the laws and legislation of the country, or applicable standards and codes, or statutory requirements. My recommendation is that you follow this closely, and if there's any change, issue your notice immediately. Okay, now questions. We have many questions from before, so I'm going to have to reply them before. And I have some more questions here. 1, 2, 3, 4. Okay, guys. Let me first go through this previous questions, and I'm going to have to look at this later. Okay, we have a question which says, FIDIC Silver Book is applicable. What happens if we fail to notify in time? Say we were 3 months late. The works were delayed due to, let's say, late approval of vendors, and we did not notify immediately because we wanted to make sure if we were delayed or not. How do we get around this? Okay, the first thing to look at, I think, in my opinion here, is that you don't need to submit your vendors or your subcontractors or your suppliers for the employer's approval under Silver Book contract. So that is important. Subclause 4.4 in Silver Book 99 states as follows. In FIDIC Red Book, however, yes, you have to get approval for them unless their names are not stated in the contract in the first place. So if the employer is forcing you to have your vendors or subcontractors or whomever approved, then they are in breach of contract in the first place. They don't have the right to ask for that. And if they are asking for this, and if they are delayed in giving you a response, and if they don't accept your claim or your potential claim based on the argument that you didn't raise the notice on time, then this is textbook prevention as far as I'm concerned. So if you challenge this, in my opinion, you will have a very strong chances to win. So, and as I said, in this OHL and Attorney General case, it's a key case. You can also argue, in addition to prevention, you can also argue that the time bar requirement starts from the date when the issue crystallized. I mean, when the delay event consumed the float and rendered critical. I mean, it rendered on the critical path. It became apparent that it would be a problem for us. So there are two things you can use here. First, the prevention, and second, it now only became a problem for us. Therefore, the 28-day period starts from not that date, but this date. Just a second. Just a second. Okay. Yeah. Another question is, if the claim notice is obviously time barred, but the contractor submits a claim anyway, will the engineer consider the claim and issue detailed determination in respect of all elements of a request, e.g. factual matters, entitlement, quantification, etc., and reject the claim due to time bar reason, or just in one sentence declare that the claim notice is time barred and based on such declaration reject the claim? FIDIC 99 applies. Well, to be honest, this is a common question. I mean, this is a common, let's say, ambiguity in FIDIC 99. But now in FIDIC 2017, they fixed this. It's been significantly improved in this regard. A lot of people were asking this question. I mean, or they were asking the difference between an initial response of the engineer and whether the determination applies or not. So it's a fair question. So as you know, first the contractor should send the notice to claim within 28 days, and within 42 days, thereafter, the contractor should submit the full detailed claim file to the engineer. The thing is, especially for claims which have a continuing effect like EOT claims, it is not practically possible to reach to a final decision until the claim is matured to a certain extent. However, the engineer has the right and has the obligation to issue an initial response. Now it's very clear, as I said, in the 2017 suite. They separated, these things. There's a new subclause called the initial response of the engineer, yada, yada. So when the engineer receives the details, not the notice, but the detailed claim file, he needs to make an initial response, especially with regard to the contractual or legal merits of the claim, instead of issuing a determination forthwith. So the engineer needs to make a prima facie, it's called prima facie, in the first instance, review and issue his observations and comments. The contractor has the full right to disagree with these observations, and in that case, the engineer needs to then act in accordance with 3.5. He should either agree or determine on the matter. Now, what should this determination, or what details this determination should have? There are different opinions in this regard. Some people say, even though it's time barred, you have to look at other things, even the cost impact. You have to go through the contractual merits and yada yada. In my opinion, and I think this is the presiding view now, is that you don't need to. I mean, the engineer, yes, he has to give a detailed. He has to give detailed comments on the determination, but these detailed comments, if the claim notice is obviously time barred, which the question says, if it is obviously time barred, then in my opinion, the engineer does not need to go through other details, but he has to provide a detailed explanation as to why he considers that the claim is time barred, not the whole thing. So it's not one sentence, but it should be determined, should be a detailed explanation only in relation to why the engineer considered this time barred, but not the whole thing, not the quantification, not the review of the invoices or anything. Wow, we have many questions. Okay, guys. Another question is FIDIC 99. If any instruction of the engineer for variation under clause 13.1 Another variation proposed under 13.3 causes the contract to stop some current activities and result in abortive works and idling resources. Can the contract just include its costs in this variation, or does he need to give notice on 20.9? In my opinion, yes. I mean, he can, because these abortive works especially is direct cost. It's a direct consequence of the variation. So in my opinion, the contract has the full right to include these costs within his cost assessment. If the engineer for some reason is not willing to pay, of course, by the way, it depends on what idling resources here mean. I mean, because in FIDIC contracts, usually indirect or consequential loss is not something you can straightforwardly claim. But I'm presuming that especially abortive works means abortive work. I mean, you made some commitment to your subcontractor, and now there's something else. The scope of work has changed. Therefore, there are some changes in the subcontract as well, and this may cost money. So I think this can be included in the in the variation. If the employer is not willing to pay, then you can raise a claim under 20.1 as usual. Oh, this is a long one. This was really time consuming, for me to reply. Is the employer required to give notice under clause 2.5 for deduction of contract charges under subclauses 4.2, 5.4, 9.2, and yada yada? Okay, let's look at each and every of them. Clause 4.2 is performance security. Now, again, this is a long subject, but does the employer need to make a claim to call the bond? No, especially if the performance guarantee, which is usually in the form of a bank bond, if this performance bond is unconditional, on demand, then no, he doesn't need to raise a claim. However, in order for him to be able to, presuming that the calling of the performance bond was successful, which is never straightforward, in that case, in order for him to be able to deduct certain sums from the performance bond amount, then such sums should be ascertained in accordance with the contract. So the employer doesn't need to invoke 2.5 to call the bond, but to make any deductions from the bond, yes, all these sums should follow the contract mechanism. The employer needs to make a claim under 2.5, and the engineer has to determine under 3.5. However, in some jurisdictions, the employer has the right to hold the full performance bond amount, irrespective of these things, which is another story. It's a very long story. 5.4. Evidence of payments. No, not necessary, because it says the employer may, at his sole discretion, pay direct to nominate subcontractor part of all such and yada yada. So does he need to make a claim under 2.5? No, not necessary. 9.2, this is similar to 9.4, and I think 9.4 clearly spells out that the claim should be made under 2.5. So yes, I think yes. 9.2, for 9.2, the employer needs to make a claim under 2.5. 10.2 is taking over of parts of the works. Frankly, I couldn't understand how an employee claim would be applicable to this. So maybe I may need some further information on that part. But if after all, if the employer considers himself entitled to something in connection with the contract, then he's supposed to make a claim under 2.5, just like the contract. And for your information, in 2017 suite now, the employer's claims is not a separate clause. They merge it one clause for claiming of both parties. Of course, there are some nuances between the claims, but it's the same clause now. It's not only contractors' claims and employers' claims separately. It's one clause. 11.4, failure to remedy defects. Yes, the employer has to claim under 2.5. 11.6, this is a good question actually, the further tests, because these tests shall be carried out at the risk and cost of the contractor. However, if the contractor argues that reasons for retesting were not attributable to him, solely attributable to him, then he needs to claim, the contract needs to claim and ask for determination. But in other cases, as I said before, in order for the employer to be able to make a deduction or settle or countercharge or whatever, he has to operate the mechanism in 2.5. This is a very good question actually, and this I had to do some searching to find a response on this one. 11.11, clearance of the site. Long story short, yes. And this is clarified in 2017, because in the FIDIC 19 suite this wasn't clear, but now it's clear. It says, this is from 2017, the employer shall be entitled, subject to subclause 2.2. 2.2 now is the claims, for the employer or the contractor, to payment by the contractor of the costs reasonably incurred in connection with or attributable to such sale or disposal. The sale here means the contractor didn't clear the site. There are still some things, and the employer is selling these things, to get rid of them. Such sale or disposal and restating or clearing the site less an amount equal to the monies from the sale. But this, brings another question. Who will operate this? I mean, who will operate this process after the performance certificate? Because we're talking about end of defects liability period, and I think another couple of months thereafter, which means, or at least it implies, that the engineer somehow needs to be on board, after the performance certificate and a couple of months thereafter. So this may have complications in real life. However, for example, the engineer may need to the employer may need to delegate another engineer to deal with such matters, especially if the engineer is a consulting firm and if their contract expired with the DMP. 18.2, insurance for works. There are various aspects, and I'm not sure which one was being asked, but for deductibles and etc., no, you don't need to issue any claims. However, in relation to 18.2D, yes, you have to the employer has to make a claim under 2.5. Okay, another question. FIDIC 99, can we apply clause 14.2 omission for remeasured contract also? There is a huge reduction in remeasured quantities. Can the contractor claim his loss of overhead and profit? In my opinion, no. Because in order for such thing to happen, the design needs to change. I mean, that there needs to be a variation, as you know it. If the quantities, if the increase in quantities is merely because the BOQ quantities were low or whatever, unless the design has changed, I think no. I don't think the employer, the contractor has the right to claim loss of profit or overheads. However, if the quantities are not provisional yet, I mean, if these quantities are provisional, that's a different story. I'm talking about non-provisional quantities in the bill of quantities of a remeasurable contract. Are not provisional yet depend on certain information provided by the employer, which however may not be reasonable for by an experienced contractor, cannot be checked due to access, etc. Then maybe, yes, maybe in such rare circumstances, maybe a loss of profit claim can be made. At the same time, the quantity increases tremendously. Can the engineer recover additional overhead under 2.5? First and foremost, the engineer cannot recover anything because the engineer is not a party to the contract. And if the engineer is, incurring additional costs in relation to this increase in quantities, he has to make a claim under his contract, a professional service contract usually, with the employer. As for the employer, can he recover additional overheads? No, I don't think so. Okay. So now let's look at the questions we received session. On Mark's question, I mentioned that the differences between FIDIC 2017 edition, it's a very long story, and I tried to cover some points. You need to bear with me on that. Ammar, it's a very long story. And Dinishka asks, can you please explain some details about following the time bar provisions for EOT claims and cost claims related to EOT disruption prolongation cost claim relevant to the EOT, especially when the notice should be submitted for the EOT and then the relevant EOT cost claim? Well, there's no difference in relation to an EOT claim or cost claim or anything. I mean, the time bar applies when the contractor becomes aware or should have become aware of an event of circumstance that may yada 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 it may have an impact on the project. So there is no practical difference between time bar provision for EOT claims and cost claims. So I don't know. Maybe you may need to provide further explanation on your question, Denishka. Jermaine asks, how do time bars work in request for extension of time? For example, if the client fails to respond in the specified time. Well, again, this question is how do time bars work in request for extension of time? This is clearly spelled out in the extension of time clause or in the clauses. So, Jermaine, maybe you may need to provide further explanation on this one. For example, if the client fails to respond in the specific time, I mean, are you talking about the client fails to respond to your claim in relation to an extension of time? Okay, Jermaine says yes. So how do time bars work in request for extension of time? For example, if the client fails to respond in a specific time. Okay, so now you're talking about you made a claim and the employer failed to respond in time. This is slightly complex because late response of the engineer does not automatically give the right the contractor to go around the time bar. So or it doesn't mean a deemed acceptance, but it may mean a deemed rejection of your claims. Yes, the engineer under all circumstances they have to reply within the time period stated in the contract, and within reasonable time periods. But what if they don't do it? Does not give the contractor additional rights in relation to time bars. Christian asks, if you're using advance warning in notifying the engineer employer, would this automatically be used by the contractor as notice, or does the contractor needs a formal? Yes, the contractor needs to send a formal notice when it becomes apparent, when it becomes certain that this advance warning event will be a problem for the project. So it's a very good tool, as I said, to use in between. And the time bar will only start when this advance warning issue becomes an actual problem. So first, you will notify the employee. You will have the chance to notify the employer without irritating them in a spirit of cooperation. Yet, the clock for issuing the notice will not start ticking. It's very useful. It's very beneficial for the contract, or for all parties, as far as I'm concerned. Denico asks, contractor failed to send the notice to the engineer in 28 days of time, but later submitted the claim with respective documents, but the engineer rejected the claim. But there's no clause in the contract, no additional payment and EOT is granted for the failure to send within 28 days, except notice provision is same as FIDIC 99. Is it condition present? Is the contract entitled to claim? Well, if it is identical, I mean, if the provision is the same as FIDIC 99, then I'm afraid, yes, it is condition present. And the contractor may have lost his entitlement to the claim. But as I said, it depends on many things. But on the face of it, I can say that yes, it's condition precedent, and the contractor may have lost their entitlement. Nizar asks, how about if in FIDIC Red Book the work can be verified as their work, but the contractor insists to consider it as VO? Well, it depends on the nature of work, because well, if the whole activities in relation to this extra work can be paid, let's say, under the day work schedule, this may still be subject to a variation, because day work schedule provides rates for possible additional works. But if the quantities are significant, then this may be subject to a variation. So we need to look at the actual request of the contractor in this regard. So I cannot say yes or no on this. We need to see the request of the employer, especially if there's a time impact. Then I would say yes, the contractor may insist on a variation. But after all, as you know, the engineer has the right to determine on this. Dima Laranthe asks, in remeasured contracts where the overheads are in the rates, when the quantity increases, can the employer deduct increased overheads? If no, okay, in remeasurable contracts where the overheads are in the rates, okay, so the rates are sort of all inclusive. When the quantity increases, can the employer deduct increased overheads if no EOT is granted? Well, I'm presuming this is a FIDIC contract, FIDIC based contract. The thing is, if the quantities increase significantly, usually it's 10%. In Pink Book, I think it's 25%. So let's say 20%. Then yes, the engineer has the right to consider. Actually, the contractor has the right to claim a new unit rate, but the engineer may also have the right to consider a new unit rate in order for addressing the overhead issue. So it depends on how much the quantities increased and the reason for increasing of the quantities. If the reason of increasing of the quantities is a variation, then no, they cannot deduct anything. The employer cannot deduct anything. But if there are no design changes, no variations, if the quantity significantly change, then it depends on the magnitude of the change. but it's very difficult for them to on the first level. Again, Vima Larante asks, in a remeasurable contract, can the decrease in quantities considered as omission and evaluate? And again, it depends on the reasons of the decrease in quantities. If it is a variation, then it's a straightforward omission. But if it's not a variation, then no. A follow-up on the question from Dinushka. Can the following be followed? The contractor issues notice to claim to EOT because of a delay event caused by the employer. Contractor receives the finalized EOT from the employer, and the contractor issues notice of claim for cost applicable to the granted EOT period. Some say it's a valid process was notice of claim the contractor will claim. And to be honest, I don't see the point of so if you issued a notice of claim to extension of time, then I don't think you need to issue another letter in relation to the costs, because EOT may also mean, and usually always means, that you will incur additional costs. And if this is a compensable delay event, which seems so because you're saying it's caused by the employer, then one notice would be sufficient. Some say this is a valid process, but some say notice of claim saying that the contractor would claim EOT for employer's delay should also include that the contractor would claim for costs related to say the EOT period. No, not necessarily. No, I don't think you need a separate notice for that, because as I said, EOTs are almost always have a continuing effect. So what you need to do is you basically submit an impact report every month. So this the period between you raise the notice and the employee replied will also be subject to a further assessment on the same agreed principles, or whatever principles are in place in relation to the prolongation costs or other costs. So you don't need to issue a separate notice, as far as I'm concerned. The same notice would be sufficient, because this is an extension of the delay event in the first place. In my opinion, you don't need to issue a separate notice for that. Okay, guys, any more questions? Notwithstanding the laws and legislation of the specific country, is the engineer due to bound explicitly? Yes, of course. Yes, of course. As I said, Simon, in order for the contractor to play the low card, almost always you have to go to the court, or you have to go to the tribunal. It is very rare for the engineer to go with, unless this is an obvious and well-established thing. The engineer, if I were the engineer, I would do the same thing. I mean, I would be very reluctant to operate something outside the contract, unless, as I said, if this is well-established, if this is very straightforward thing, in the laws of the country. As you said, the engineer would be engineer's duty is to strictly follow the contract. Was that clear for you, Simon? So put simply, if I were the engineer, I would tell the contractor to go to court and get a court order. Then I will do whatever you want. But until and unless then, okay, guys. Do we have other questions now? No.
All right. Thank you all so much for coming, and Cagdas, thank you for really going into so much detail. As I say, I think this is the longest webinar we've ever had. All right. All right. Thank you, everybody. See you next time.
Thanks, everyone. Bye-bye. Bye-bye. Cheers.